Kurt Verone, and welcome to another edition of Fire Law Roundup. This one for August 15th. We're doing it the 14th, but it's for August 15th. We try to get it out every Monday. And let me just do this. But Brad, what an interesting week. I was going to say crazy.
Yeah.
But we got five great cases this week.
This is a great, so I'm so excited to do this, and if you have not watched before, we are setting the bar high on this one. I got to tell you, this is great. All right, ready?
Yeah, I'm ready.
Let's start in Alabama, because why not? We just don't get to be there enough. And this, I could look, allegations, we always start off the show saying these are just allegations. These are not facts. But this, like all of them, is you could see how it happens, but it's crazy. So in Alabama, initially, let's make this real simple, right? They file a lawsuit, and the lawsuit claims that you're using a formula that gives us a certain number of hours, right? Is that the 212? Which one did they do?
Yeah, it's a pretty much a pretty standard. There's nothing out of the ordinary with this lawsuit. It's a very common FLSA claim that people's overtime is not being calculated correctly. Okay, right. It really, it's just another very common, the most common allegation in FLSA claims. By the way, it's the city of Gadsden.
Okay. Yep. And it's crazy that to me, it's crazy that employers look. You either are having them work too many hours without paying them the overtime, or you're not, right? And that it's such an easy thing to calculate. This is not difficult. Is a firefighter working more than the allotted hours in your, in your pay period? This isn't difficult. However, they file that lawsuit. This is an amendment to the lawsuit because the employer doing things which allegedly, right, I could see them saying, but they make these threats, which I believe, if true, do amount to retaliation, right? And but clearly, you can see how someone could make the claims or make these statements. They're like, well, now we're not going to have double overtime on working on Sundays, and now we're going to have to reduce your sick leave accrual, right? And all of these things that you're saying to your employees are just so retaliatory, saying, well, now that you filed a lawsuit, we're going to have to take all these benefits away because we can't afford it anymore. If true, boo-hoo, right? I mean, to the employer, come on. If you're violating the law, allegedly, right, by making people work more without paying them overtime, more than the hours you're allowed to do in the pay period, and now you tell them, well, since you sued, you've ruined the party for everybody. You can't do that. You're quelling future lawsuits, right? And you could see some backroom talk. I could bet some backroom talk from some employers saying, or even people in the union saying, boy, if you raise this, you're going to ruin, another good thing. And you just can't do that.
Yeah, I feel bad for the chief here too. It sounds like the chief is stuck between the personnel manager or whoever, one of the city administrators that's kind of calling the shots, and the firefighters. And unfortunately, the chief, at least according to the complaint, made some comments that, hey, it's not me that's doing this, but this is what the city's going to do. And that I've seen chiefs in that situation. Unfortunately, I've put chiefs in that position, and I said, are you sure you want to say that? Yeah. you know who you're talking to. Yeah. This is not what I want to do, but I've got to do it. And then the chief gets on the witness stand in the trial, and he's like, yeah, that's not my recollection. So
right. And it's tough too here because somebody approves their time cards. How does it happen, right? If your allotted hours is whatever, 212 or 208, whatever it is, under your pay, under what you've negotiated, how do you see, okay, well, we have 5 more hours than that, but we're just going to pay it straight time?
Well, this was more about the paying the proper rate. It wasn't so.
Oh, I thought it was they're working too many hours.
No. It was about paying them the proper rate. And you have firefighters that, for example, let's say you have an engineer. You have an engineer, and I think it was an officer. I don't think they called him a lieutenant, but you have 2 ranks that work overtime, but they work as a firefighter or whatever. you can't just pay them at the firefighter rate. You have to pay them at their rate. And there was a few other things. So it was, again, very common type of regular rate questioning about what should they have been paid. And they also happen to have a very, one of the best law firms in the country that represents a lot of the, on these FLSA claims, representing them. And, they didn't pull any punches here on this retaliation claim. And, if the allegations are true, the city is going to get hit with, with the retaliation.
Well, and look what you're doing to those firefighters. You're saying, you three people who, want your proper rate, you're ruining it for everybody. And my God, why? It seems to me if I was in this suit, and whenever I'm in any suit, I issue a very simple directive to my clients, or tell my clients to issue a directive. No one talks about it. You don't say anything good. You don't say anything bad. My answer is, if you have a question or statement, go talk to whoever, right? You don't talk about it. You sure as heck don't make these comments if they were truly made. So anyway, it starts off a crazy list, but that's one of the 5 we got. And that's
one of the more normal ones.
Yeah.
Where do you want to go? Where do you want to go from there?
Let's go right down the street for me to Rochester.
Okay.
Rochester obviously was just in the news for some bad things. They had a police officer shot and killed. They had the EMT with Monroe Ambulance who was arrested by the police. And so now we're back in Rochester. So strangely, almost 3-4 weeks in a row, we're back in Rochester, New York, not Minnesota. And this is insane, less insane than the next one, but almost insane. So here we have a Rochester firefighter, right? He claims he was forced to attend a party by his captain. I guess his captain says you got to go. Now, this guy's a 14-year veteran, so he's not new, right? But I presume he's African-American. He goes to the party, and unbelievably, although we shouldn't say that since discriminations are, number one claim here, but unbelievably and allegedly at this party, they're mocking Juneteenth, right? The actual date that slaves were freed, and which is a national, now federal holiday. I suspect where this came from. He's ordered to go to this party, and so he has to be there, right? So he's subjected to be there, as clearly work related because he's ordered to be there. And mocking is not a good word. They allegedly put a bucket of fried chicken below pictures of Juneteenth. They take pictures with these pictures, as we call it, Exhibit A and B, right? And they just engage in a bunch of alleged racist, activities and have a party mocking it. If this is true, you must be kidding me. I mean, I don't even know what to say to these types of things.
There's nothing you can say. And I think in a career department, when you're assigned to a company and the captain says, let's go, we're going over to somebody's house, or we're going to an event or whatever, you get on the truck and go. It's not so much that I don't think the captain went to this particular said, hey, you are coming with me. The rest of you don't have to, but you're coming with me. I think it was more that, hey, we're headed out, get on the truck, let's go. And one of the places that they went, or the only place that they went, was this party. And, I think it was last week we talked about parties and on-duty firefighters and how these things can get you in trouble. And
drinking and drugs. We've seen a number of cases where they're providing drugs at parties to, off-duty, on-duty, whatever, firefighters.
Are you able to get the complaint on this one?
I tried about an hour ago. It is not accessible yet, which is really strange because electronic filing is almost immediately accessible. I searched by his name and by Rochester, and I could not find any suit as of yet. So maybe
there's nothing on the federal side either. So, but sometimes the news media gets ahead of things. They'll say that a suit is being filed based on a threat, or the lawyer will send them a copy of it saying we're going to file this, and then it doesn't get filed. So I was a little bit cautious about it, insofar as without the complaint, we're going third hand now from the news media. So the blog has a link to a news video about it. Gives a little bit more story. The captain has been disciplined, which, appropriately so. But my sense when I see a captain in this situation that got disciplined, I immediately say he's not the first one to do this. Maybe the first one to go to this type of an event, but this is something that company officers have this discretion to go to if it's in their first in area. And
this is going to rip the scab off a serious wound in the city of Rochester, because these things don't normally happen without some systemic, right? And I hate that phrase, but truly here, without some systemic history of racism. And we don't know how many people were at the party. We don't there's a lot of things we don't yet know. We will once we see the complaint. Well, at least we'll see the allegations. But this really, I hope it's not true. For the sake of everybody, I hope it's not true. But wow. So let's stay crazy.
This is the craziest. This is the craziest one.
San Francisco, my God. So the understandably, prior to the release, you appropriately point out, prior to the actual release of the decision on, reversing Roe v. Wade, although as everybody knows, everybody had read what they believed the decision was going to be because of the leak out of the Supreme Court, which I never believed really happened. My wife says, "Hey, did you just hear the Supreme Court, a decision got released?" I said, "Never going to happen. You're totally wrong. Not true." In that event, they go to a hockey game? And
basketball
game.
NBA,
basketball
NBA playoffs.
Oh, yeah, right. Oh, Jesus,
there's no
right.
New York team there. That's why you don't care.
No, I know.
You don't care
Otherwise,
about the Celtics or the Warriors. No.
Yeah, no. But she goes down on the court, which should have cost her $25,000, right? For these anyway, but she goes down to the court and she engages in what she claims civil disobedience. Let's assume that's all true. And she's screaming, about with some other people, I think, screaming that, it's unfair, etc. She's fine. Civil disobedience. And frankly, I'm all for it because it doesn't involve burning anything down. So what's alleged, right? And we got to be really clear what's alleged, unless some body camera comes out or whatever. But allegedly, a police officer is saying, "You calm down, or we're going to, make you calm down." Paramedics get here for, I have no idea what reason, right? This did the police call the paramedics? I don't think they're police / paramedics, is my guess. Like in Nassau County, New York, they have police who are paramedics, but I'm guessing they're not police paramedics. So they apparently, for no reason whatsoever, call the paramedics. And we just did a radio show on this, so you might as well link back to that. And they allegedly, I don't know whether it's Haldol, Valium, whatever it is, they allegedly sedate her.
Not ketamine.
Yeah, God, hope not. But they allegedly sedate her against her will. She has no medical condition. She's not a patient by any means, right? Unless we're missing something. But her allegations are they just inject her to sedate her to calm her down. That is a serious violation of just Fourth Amendment, First Amendment, so many things. So if this is true, the police officer is going to jail. I mean,
maybe medics as well.
Well, whoever did it, right? Whoever actually administered, I think you're going to jail. Forget the civil suit. I think it's criminal. It's assault. You can't. I can't even imagine this.
I got to believe there's more to it, because according to the complaint, all she did was she just said, overturn Roe, hell no. That's apparently all she said. She just kept saying that. And the next thing you know, they're wrestling with her, they're restraining her. Well, if that's all you're saying, why, overturn Roe, hell no. If that's all you're doing, why would somebody want to wrestle with you?
Right. Here's the one thing I'm pretty sure.
Why would they need to sedate you if that's all you're doing? So I think there's a little more to the story, but who knows?
There's got to be 400 million videos of this thing, right? The NBA playoffs, everybody's got a phone. The entire place is on, right? And she went down to the court.
My mind went in a different direction on this one, because the first question I had was, is the Chase Center a publicly owned facility or is it privately owned? Because you have a right to express your opinion and protest, but you can't come in my living room and do it. You got to do it in a public place. And just because the public is invited to a place doesn't mean it's the same as a public place such as Town Hall or the City Square, or wherever else people are allowed to express their First Amendment rights. When you come into my house or my office, you don't have any First Amendment. I don't have to honor your First Amendment rights.
This was a ticket holder event. Right.
But yeah,
and you've got a ticket holder event, which kind of leans away from, some would argue, well, that's what makes it public. I don't. Right. That's what makes you able to be regulated in that area. And look, on the back of the ticket or somewhere else, it may refer to rules, but you don't get to walk wherever you want. You can't just walk in the middle of the court.
Yeah, well, if it's government owned, I think she's got a stronger leg to stand on when it comes to the First Amendment part of it. But if it's if it's privately owned, you don't have the right to go into somebody's, private business, private property. And no matter how righteous your protest is, you still don't have a right to,
Now, all of that said, that doesn't give the police the right or a paramedic the right to
or me. You. I can't physically assault you.
Right.
That's right. I can call the police and then they can do what they need to do to, based on what's happening.
They can arrest you. They certainly can't sedate
you. Certainly for trespassing, yeah.
So, and if this is true, this will go back to something we talked about, I don't know, 2 weeks ago or whatever, when, paramedics and firefighters put themselves in a bad position when they want to befriend the police. Oh, yeah, I'm going to befriend the cop and do whatever he says, like inject you because the cop told me to. If you, Mr. Paramedic, Mr. or Mrs. Paramedic, think you're off the hook because the cop asks or tells you to do it, no, they do not control what you do with that needle.
Well, I just ran my data, and you and I haven't talked about this, but I just ran my data again. I'm going to be doing a class for Firehouse Expo in September, and I try to analyze the data and look at trends and stuff. And big uptick in the last 12 to 18 months on firefighters on police assist type calls being sued. And it went from something that was very, very negligible to a substantial number of firefighters being sued. We also have that criminal case that we talked about. I believe it's Aurora, Colorado, where firefighters are facing manslaughter charges for injecting an unruly police person that was apprehended with ketamine. And that's not the only ketamine suit. So there's definitely an uptick in fire departments being sued and firefighters being sued on police assist type calls.
And I'm all for the firefighters wanting to work with the police as we should. It better than the alternative.
In the other room, my son. So
yeah. Oh, there you go. Right. So, but let's, this is a little different. Don't let a bad cop make you a bad firefighter, or vice versa. So I can't believe we're to this one already. We're flying through this, but so let's LA County. This is actually, I think it's kind of typical in some sense, but here you have a drug test administered. The drug test comes back with what was alleged to be a false positive. And apparently, I think you commented, is a very well-known false positive for somebody who's taking with attention deficit disorder. It comes up, an amphetamine comes up as methamphetamine. Mm-hmm. So the individual, rightly so, is, placed on leave or suspended, but ask for reconsideration. What they do, which of course is pursuant to their policy, every good drug test does a split sample. So they said, listen, we're not going to do a different type of test, but we'll run the sample again. The problem is that there's no problem with the sample, right? It's a problem with the result, that the result is going to render a false positive for methamphetamine for an amphetamine. So this person's now, looked at as a drug user, right? And is claiming, look, it's for ADA. It's like saying I ate a bagel with poppy seeds. I may have tested positive, but
I've had that
right?
one, yeah.
So in any event, the individual's terminated. And it's, there's a lot of violations. You've got ADA, right? You got the Recovery Act, maybe. I don't think that's been alleged, but I could see that kind of. But, the ADA is the big one. But now and it's interesting. People should understand one of the things they allege is failed to reasonably accommodate my disability by giving me a drug test that doesn't come up false positive. I think that's a good claim. I've seen that other places. I don't think this attorney's making it up. There's a good history with that. But as an employer, look, run your drug test, fine, do the split sample. But if somebody's if you can do basic research, and maybe they did, but you would find out, right, that no, this test has a history of false positives. Come up with another way. And the employee was willing to share the drug and the reason they're on the drug, which they don't have to do. And, you know, the burden shifts, right? Now the burden should go back to the employer to say, we've got to come up with a test that doesn't pop false with this type of drug. And, you know, I don't know whether this is a problem employee where they were happy to get rid of the person because, you know.
Well, I didn't include this in the write-up, but apparently in the complaint, he referred to himself as having acquired the nickname of Sleepy Joe.
Okay.
So,
yeah.
and he said that it was related to his disability and inability to sleep, and he'd come to work tired, and there was several reasons for it. Maybe even his medication, but at any rate, he had somehow acquired the affectionate nickname of Sleepy Joe. His first name is Joe. So
yeah, okay, well, he's probably not our president, but so this is a good example of a bad employer practice. And if the employer wanted to get rid of the employee, this is not the way to do it. ADA claims, you know, is not something you want to face. And his allegations are pretty strong. You know, assuming it's true, his allegations definitely, you know, force, as a matter of law, are going to force the employer to explain why they wouldn't accommodate a test. I think this is going to come down to a lot of science argument, though, right? Because you've got to show that the test is a false positive and it has a history.
Just because somebody is on amphetamines doesn't mean they could not also be recreating with methamphetamine.
Right.
You know, so that's another possibility. I'm going to tell you, I know a number of chiefs from LA County, and they're squared away. Their front office is as squared away as any fire department is. So, you know, there's probably more to this that we don't know. Always. But, you know, I think it's interesting, you know, the flow, the facts, the flow of the case and how it got to court, I think is interesting for folks to understand. And, you know, we'll see where it goes from there.
Yeah, there'll definitely be more on this. You know, you got to imagine that the county is saying we could show the test is valid, or we could show something else. But in any event, it goes back to something we talk all the time: the burden shifting analysis, which we did a lot on the other week. Right? Is you made they clearly made what's called a prima facie case, right, of discrimination. I think they did, and now the burden is going to shift back to the employer to say, no, we had a reasonable basis for denying the request. Yeah. So, okay. I'm going to leave, you know, this is such this is my favorite week because these cases are just so good. Yeah. But, you know, here we have I think I'd almost say that your title is a little misleading, but so the title, Wisconsin IFF local president fired. He's not fired as president, right? He's fired as a firefighter over a social media post. And clearly, one would argue that he's speaking on a matter of public concern, which is saying there aren't enough ambulances in place on a certain day, certain time, and that he gets terminated for making inappropriate comments. And I'm really shocked if that's all he was making comments about, that, hey, we don't have enough ambulances. They must have been gunning. If that's true, they must have been gunning for this guy, because that's a pretty innocuous comment that anyone would have thick skin on, and more so would say, you know what, look, we'll determine, as chief or city, we'll determine how many ambulances are enough. You don't. And it's totally reasonable for the IFF to make a comment of we're understaffed, right? We're not serving the community.
Right.
I would argue that is a matter of public concern. Obviously, it also relates to the job, right? Hire more people, etc. So it's got a mix. But man, to fire him over this,
well, you know, the Pickering case. A lot of times we tend to think about the Pickering balancing test when it comes to the First Amendment. But there's another part of Pickering that talks about can someone be disciplined for stating something that's false? And the Supreme Court said no. That if you're going to discipline somebody just because what they said is wrong, that could violate their First Amendment rights, assuming what they said is entitled to First Amendment protection. that it's a matter of public concern set as a private citizen, and the balancing test, the balancing part of it. But in this particular case, I'm thinking that even if he's wrong, they have to prove that it was maliciously false. It's the New York Times standard. Okay, you've got to show that you either knew what you were saying was false, or you were reckless with regard to the truth or falsity. Just being wrong isn't enough to punish someone when we're dealing with something that's a matter of public concern. It's got to be maliciously false.
Yeah, and I was looking this at, if you want to look at it that way, if it was made prospectively that I'm going to try to induce fear in the public because you are not going to put a certain number of ambulances on, et cetera. In the past, it's hard to make an argument like you panic the public, or you created dissension in the fire department. I don't know. I just there's got to be more. I can't imagine you just getting terminated for that comment or these series of comments.
Well, in prepping for this, I sent you a link to an article just about what's going on in Wisconsin. And I had no idea Wisconsin at one time had very robust collective bargaining laws for public employees. And then there was some sort of looked like a revolution, anti-employee revolution in 2011 that kind of set them back a little bit. And so it seems like collective bargaining is unsettled, but at least based on what I could gather in the time leading up to this, it does seem like employees have a right to engage in concerted activities. Now, those of you who've been through my social media class are going to go, oh, here he goes on concerted activities. But we have two sets of rights. Most firefighters, particularly in collective bargaining jurisdictions, we certainly have First Amendment rights. We also have this other set of rights, which is concerted activity rights, which when you're talking about work and you're talking about collective bargaining type matters, and particularly here, they're talking about contracting out things that used to be done by members of the local. You're talking about something that could fit under that concerted activities type of protection beyond just the First Amendment. And it just opens Pandora's box to a bunch of other defenses, or not even defenses, claims that the union president would have, in terms of, so sounds like he doesn't necessarily need any more, but that concerted activity protection may also come into play, in terms of where he goes with this next.
Yeah, I guess I'm just a little, there's got to be more. Nobody, I mean, maybe, but normally a bigger government would not take this route to punish somebody for making these comments. And more people have thick skin, unless this was just a final straw with this guy. They didn't care, let the chips fall where they may. But if my advice is true or not, if I always say, listen, do you want to just suck up a day of bad press, or do you want to be in a court for the next 2 years on a very difficult topic? Judges don't understand Pickering, and judges, right? And all the law, we've discussed a bunch of good laws that we think are helpful, or cases that are really helpful defining it, but they just evidence the confusion that exists, that people really don't understand the rules. Pickering's so vague anyway, and as it's applied.
Yeah.
But to just don't terminate somebody for something they say unless there's a real issue with it. I tell people, just suck it up, Buttercup.
You don't like somebody, or you feel like this person's a thorn in my side, and now you're giving me the chance to take them out. And, it's sometimes they just can't resist, taking that option. So.
And if unions are going to go nuts. Unions are going to say, look, you're going to force us. If you don't, to the court, they're going to say, if you don't make this conduct, prohibit this conduct by imposing a big judgment against, this employer, then unions everywhere are going to be subject to, the termination of their presidents for sticking. I could see all the political ramifications, and I wouldn't want to be, the employer in this, if true. So,
right.
That's again, what we got.
It'll all come out in the wash, probably. Hopefully. So.
Yeah, and this was some dirty wash for this week, I gotta say. But if we could have assembled 5 more crazy cases, this is a great. I don't want to see the fire service relegated to this level of crazy all the time, but man, it makes this part fun.
Yeah, there's actually a couple of other cases that I didn't have a chance to, and I'll include those in this week's newsletter. I'll include links to those other stories that would, there's only so much time in a day to cover this, but fascinating week this
All
last
great
week
stuff.
was. So
all great stuff. That's what we got.
All right, man. All right, well, that'll do it for another edition of Fire Law Roundup. We'll see you next week.